delighted to welcome you all to the Supreme Court for the final lecture in the Four Courts 100 lecture series. This lecture series has been a key element of the broader Court's Decade of Centenaries commemoration programme. Launching that programme in the Court of Appeal on the 14th of April last, 100 years to the day after the occupation of the Four Courts began, the Chief Justice observed that whereas history has always passed through the Four Courts, with controversies about major social and political events finding their way here in one form or another in search of judicial resolution, in the period between the 14th of April 1922 and the 30th of June 1922, when the occupation came to a fiery and destructive end and the Four Courts largely lay in ruins, history lived here. A wide variety of topics have been addressed in previous lectures, ranging from aspects of the occupation itself and its physical impact on the Four Courts to the broader historical, political and legal context. Through these lectures, we have both stayed here and ventured out into the wider world out there, in which the Four Courts and the system of justice administered within it and from it has always played a prominent role. It seems entirely fitting that on this, the final night of the lecture series, attention should turn to the impact of the events of 1922 and the events leading to and following on those events, on the legal system itself and on its constituent actors. I cannot think of anyone that is better qualified to address these issues than our speaker this evening. It's a privilege as well as a great personal pleasure to introduce Dr. Bláthna Ruane, Senior Counsel, who has written widely on the Constitution, law and government and on legal history. Bláthna is also an adjunct professor of law at the Sutherland School of Law at University College Dublin. The title of Bláthna's lecture is Turned Upside Down, Law, the Judges and the Legal Profession in 1922. It's a fascinating and at times chilling discussion of the extreme legal turbulence that characterised 1922 and the wider War of Independence Civil War period from the perspective of the nascent Free State, the judiciary and the legal profession. As Bláthna recounts, on the 20th of May 1922, some 2 months after the occupation of the Four Courts had begun and little more than a month before its destruction, Lord Chief Justice Maloney, who had successfully petitioned the Crown to be allowed to describe himself as the Lord Chief Justice of Ireland, notwithstanding the enactment of the Government of Ireland Act 1920 and the partition of the judicial system affected by it, wrote to a senior British official explaining that the judges were simply waiting to see, will the tide turn or engulf us? Engulfed the judges ultimately were, of course, as surely and completely as the Four Courts complex itself was soon to be engulfed. The fate of the Crown judges and of the other actors in the legal system over which they presided deserves to be remembered as much as the fate of the buildings they once inhabited. Their story is in good hands this evening. Thank you.
Thank you very much, Judge. Chief Justice, members of the Judiciary, colleagues, members of the Court Service, ladies and gentlemen, I'd like to thank the Chief Justice and the Court Service Decade of Centenaries Commemorations Committee for the kind invitation to speak this evening. And it is, of course, a particular honour to speak in this historic chamber in the Four Courts on the centenary of a most momentous year. 1922 was a year of calamity for the whole country, but my hope this evening is to give you an overall flavour of the wider legal turbulence that characterised that year from the perspective of the state itself, the judiciary and the legal professions. The major legal challenge facing the state was whether and how the Treaty of 1921 would be ratified within the year, as was implicitly required. Following signature, there was still a complicated and politically hazardous way to go before the legal process was to be completed, with ample scope for it to be completely derailed. The British had been willing to give the Irish negotiators a treaty, which is a form of international settlement between sovereign countries, but only on condition that they simultaneously accepted Dominion status. They got Canadian-type Dominion status, which included the resented oath of fidelity to the Crown, but with extra restrictions: the right of Ulster to opt out, an Irish contribution to the public debt, defence arrangements, retention of British access to Irish ports, restrictions on the maintenance of the Irish Army, and transitional arrangements. In real terms, the British therefore held on to the key powers that they regarded as essential to them. For the Irish, at least, it was a step towards independence in that they had a treaty, granting them a level of international recognition hitherto impossible, and which helped to copper fasten the deal made with the British, and the powers of dominions were expected to expand further. Once a treaty is ratified under international law, its operation is usually backdated to the date of the original signing. The treaty had to be approved by the British Parliament, and on the Irish side, not by the Dáil, but by the largely similar members of the non-functioning Parliament for Southern Ireland, which was established under the controversial Government of Ireland Act 1920. If so approved, it later also had to be ratified on each side by the necessary legislation. It was therefore a two-stage process. In Britain, Parliament resolved on December 16, 1921, that it was ready to confirm and ratify the treaty. Legal die-hard unionists raised doubts over the agreement's legal status as a treaty and the constitutional validity of the British government's strategy of making a treaty with what was, in British legal theory, an inherent part of the United Kingdom. Through shrewd parliamentary management, these serious legal issues were sidelined until the ratification legislation came to Parliament at a later stage. British Prime Minister Lloyd George's strategy was that the treaty was presented on a take-it-or-leave-it basis. The traumatic Irish treaty debates revealed serious legal disputes, including over the legal status of the treaty itself and the new state. The Constitution had to be approved by the British and implemented by British legislation, which underscored the failure to achieve Irish sovereignty. These restrictions raised the politically toxic issue of whether the Dáil was entitled to approve or ratify the treaty, because the first Dáil had proclaimed the Republic in 1919 and its members had taken an oath to uphold the Republic. Partition was also to be made permanent if Ulster decided to opt out. De Valera also claimed that the plenipotentiaries had exceeded their authority in signing the treaty. He pushed for its rejection and further negotiations with the British to achieve external association, as set out in his famous document number 2, whereby Ireland would be independent but would accept an association with the Commonwealth. Following the vote on January 7th in favour of the treaty, De Valera had resigned as President of Dáil Éireann on January the 9th, and on January 10th, Griffith was elected President in his place, together with the new Dáil Ministry. The Parliament for Southern Ireland voted in favour of the treaty on January 14th and established a provisional government, and as the treaty had envisaged. Neither the second Dáil elected in 1921 nor its ministry was recognised by the British. The provisional government was the only executive recognised by the British, but because its status derived from the controversial treaty, the anti-treatyites did not recognise its legitimacy at all. There were thus, extraordinarily, two parallel executives or dual government during that period. Collins became chairman of the provisional government and Arthur Griffith was president of Dáil Éireann. There was a considerable overlap between the two sets of ministers, which allowed the treatyites to govern with greater credibility. Irish ratification required legislation by an Irish legislature acceptable to both sides, and of course the Parliament of Southern Ireland was not acceptable to Sinn Féin. On January 24th, a wide range of powers were pragmatically transferred to the provisional government from the British government without even waiting for enabling legislation. That still left many hard decisions ahead. Responsibility for the legal strategy for ratification fell on the new law advisor, Hugh Kennedy, a King's Counsel since 1920. Later, on March 31st, he became the law officer, and in December he became Attorney General. Kennedy had not been in London during the negotiations, although he had advised W.T. Cosgrave, who was then Minister for Local Government, during the treaty debates in Dublin. He had earlier represented the Republican prisoner Egan in the groundbreaking habeas corpus case of Egan and Macready. Kennedy immediately embarked upon what were to be roller coaster negotiations towards ratification, with relatively little support, although ranged against the far more experienced British legal team. Somewhat surprisingly, perhaps, neither the British nor the treatyites had a clear roadmap of all the necessary interconnected steps that it would take to get to ratification. Much of January to March was devoted to trying to determine how to proceed. The British wanted the transfer of power enshrined into legislation quickly and to proceed with ratification. The British, however, would not ratify fully until they saw the final terms of the Irish Constitution, but that would take time. The treatyites wanted the British to ratify quickly in case they pulled out of the treaty, but they also wanted British ratification before the Constitution was finalised. The commencement of the period allowed by the treaty for Ulster to decide whether or not to opt out, known as the Ulster Month, was linked to the date of British ratification legislation. The treatyites wanted Ulster to see the Constitution before deciding, so they didn't want time to start running on the Ulster Month until the Constitution was adopted and approved. The British were also concerned that the provisional government was not accountable to any parliament. Originally, it was hoped that an election would be held quickly, providing implicit approval for the treaty and creating a constituent assembly who could adopt a constitution and ratify the treaty. But the poll process ended up taking far longer than was expected. A constitution committee was formed in late January to prepare a draft constitution. Collins was chairman. Under severe pressure from the anti-treatyites, he exhorted the drafters to leave out references to the oath, representation of the Crown in Ireland, and other items that he thought would be provocative, believing that he could force the British to accept that. This was brave-hearted, but it was completely unrealistic from the British imperialist viewpoint. The first milestone that they reached was the Irish Free State Agreement Act of March 31st. Under the Act, the British Parliament ratified the treaty, other than in respect of the commencement of the Ulster Month. British ratification was thus not complete. The Act was to enable effect to be given to the treaty and to give it the force of law as from the date of the Act. That legislation was sufficient to allow orders to be made to grant the provisional government power to carry on the day-to-day administration. Also for the dissolution of the Parliament of Southern Ireland and for elections to be held to create the much-needed Constituent Assembly. The commencement of the Ulster Month would have to wait until the final ratification legislation, following British approval of the new Constitution. The Act also provided that an election would be called to establish a new Parliament, the election being intended for June the 16th. The British debates on the bill were fraught with die-hard unionist legal resistance. However, because much of the focus was on Ulster and further steps still had to await the drafting of the Constitution, unionist resistance failed to undermine the bill. Also, the British government's line was that the treaty could not be amended and it had to be taken or rejected as it was. That frustrated the Unionists' ability to cause trouble. In late May, the draft constitution was taken to London. The British rejected it out of hand, and their rejection was immediate and ferocious. They regarded it as a republican constitution which failed to reflect Dominion status and the other Irish obligations that were to be undertaken. The British threatened military action unless the Irish complied with their demands. The British were also incensed by the ongoing occupation of the forecourts and the Collins-De Valera electoral pact which had been made, under which they had attempted to offer a united front to the electorate, dividing up the seats. Griffith had little choice but to accept the legal changes demanded by Prime Minister Lloyd George. Crucial elements were redrafted at high speed by Kennedy in consultation with the British. Kennedy took every available opportunity to reduce the scope for the exercise of British power. The redrafting process in London was achieved just in time to enable its publication on the eve of the election on June 16th. but clearly the public had insufficient time to analyse the draft constitution. The provisional government did not disclose the extent to which the British had altered it. The election result strongly favoured the treaty, but within weeks, civil war broke out with the retaking of the forecourts. Soon, there was also confrontation between the provisional government and the Dáil courts, which Mr. Justice Hogan has already spoken about in an earlier lecture. The Dáil courts had been established by Sinn Féin in part to supplant the Crown courts, but the treatyites decided to terminate them. This turnabout followed renewed British pressure in May and June during the negotiations on the Constitution for the Crown courts to be continued. In addition, some Republican elements within the Dáil court system had become hostile to the treaty, and controversial attempts were made to use the Dáil courts to undermine it. Kennedy had also formed the view that there were legal problems and flaws in the constitution of the Dáil courts themselves. These flaws are not unexpected. The courts were created in the most difficult of circumstances, and the miracle is that they functioned as well as they did. In mid-July, most of the Dáil courts were suspended, and in later July they were terminated, with limited exceptions amid considerable controversy. With their cessation, the only courts for litigants were now the discredited Crown courts. August brought the tragic deaths of Griffiths and Collins and their replacement by William Cosgrave. The Constituent Assembly, or the Third Dáil as it was known to the treatyites and Republicans, finally managed to meet for the first time in September. The anti-treatyites refused to take their seats. With civil war raging, the security situation by then was dire. Kennedy and several members of the provisional government felt obliged to move into government buildings in Merrion Street for their safety. The provisional government wanted drastic security measures to curtail Republican resistance through martial law and the death penalty. There was, however, no constitution or legislature operating under its terms. Kennedy advised that they could proceed by means of Dáil decree, and the Army Emergency Powers Resolution was passed in late September, providing for the establishment of military courts with stringent powers of execution, penal servitude, deportation, and imprisonment. The decree mechanism meant that there was no interference by the British with a requirement for the assent of the Crown. The draft constitution was not debated until late September and October. The provisional government had made clear to deputies that the British required clauses were off limits for amendment. Notwithstanding this, an amendment was accepted into the provision of Article 12, which asserted that the sole and exclusive power for making laws for the Free State lay with the Oireachtas. That, of course, was inconsistent with Dominion status and could readily have derailed the treaty altogether if left unchecked. The British predictably objected to it, but Cosgrave and Kennedy overcame that hurdle later by accepting a clause inserted into the final British legislation in December, confirming that nothing in the Constitution would prejudice the power of the Westminster Parliament to legislate for the Free State in accordance with usual Dominion practice. So the British managed to reassert themselves again. The Constitution of the Irish Free State Saoirse Thought Éireann Act was passed by the Third Dáil on the 25th of October. It enscheduled the Constitution and also the treaty. The Act proclaimed the establishment of the Free State and decreed and enacted the Constitution. Section 2, however, contained the restrictive formula required by the British that the Constitution had to comply with the treaty, and any provision of it that was repugnant to the treaty was void. The Act also gave the treaty the force of law and was therefore regarded later as being the Irish legislative ratification of the treaty as required by Article 18. No effect was given to the Constitution until it was brought into operation by British statute and royal proclamation in December. Meanwhile, De Valera had proclaimed a rival Republican government in late October. His position was that the provisional government was illegal. As the provisional government began to use its new security powers, trials took place of Republican prisoners, leading to executions, most notably and controversially that of Republican leader Erskine Childers. Charles O'Connor, the Master of the Rolls, refused an order of habeas corpus sought by Childers following his conviction by a military court. That outcome was politically favourable to the provisional government and permitted Childers' execution shortly thereafter, which took place despite a pending appeal, but it led to a huge outcry. The Treatyites had also been facing yet another threat to the treaty. Lloyd George, who had negotiated and spearheaded the treaty, fell from power in October and was replaced by the extreme unionist Bonner Law. Suddenly, it again seemed possible that British ratification might be prevented. Cosgrave travelled to London to ensure that the settlement did not collapse at the 11th hour. Bonner Law insisted, however, on having the terms of the Constitution examined all over again to ensure that it legally complied with the treaty and Dominion status, which fortunately it did. There was still the British parliamentary process to be faced for the final ratification legislation, with the possibility of some of the previously sidelined die-hard unionist legal concerns being raised yet again as fundamental obstacles to it before the final ratification could proceed. However, by then, the mood had been altered by the Civil War. The momentum was now with ratification, and the die-hard constitutional issues never achieved traction. On December the 5th, the Irish Free State Constitution Act finally completed the British ratification of the treaty. Section 5 of it deemed it to be the act of ratification of the treaty for the purposes of the Ulster Month. It recorded that the Irish Constitution Act, passed in October, had provided that the Constitution was made subject to the articles of the treaty. A royal proclamation issued on the next day drove home the fact that the Constitution was passed and adopted by the British Parliament. At times it had seemed that ratification might never happen, but even when achieved, it was, of course, not the full independence that the Treatyites had really wanted. They had, however, got the best terms possible from an imperialist British establishment prepared to enforce its demands by military might. The British demanded a degree of ongoing control over Ireland and could not contemplate a republic within the British Empire and the emerging Commonwealth of Nations. Although the treaty was ratified, its implementation was threatened further by Republicans. Liam Lynch, the extreme IRA leader, had issued a proclamation in late November threatening to kill the members of the Provisional Government, members of the Dáil who had voted for the September Army Emergency Powers resolution, the members of the Army Council, and also most of the command legal staff officers. Just after the Dáil met on December 7th to establish a new government under the new constitution, Sean Hales, TD, was shot by Republicans. In a savage retaliation on December the 8th, Cosgrave's new government had 4 prisoners, then in Mountjoy Prison, summarily executed. That predictably evinced yet another massive outcry. And so the year ended on a despairing note, with the prospects for 1923 very gloomy. Treaty ratification was achieved after huge difficulty, but its future still remained uncertain and depended upon the defeat of the Republicans. I turn now to the traumatic difficulties faced by the Crown and Dáil Court judges and also of the legal professions. Transitional arrangements implementing the treaty in January 1922 had made clear that the Crown courts were to continue. The senior Crown judges, whose position was politically the most sensitive, were born and largely educated in Ireland, but their composition and backgrounds did not properly reflect the Irish Constitution. They were identified with British power in Ireland. The nature of their judicial roles also provoked distrust among the newly emerging radical nationalist legal elite. Apart from the hybrid political legal role of the Irish Lord Chancellor, the senior judges also had another political role when the Viceroy was away. Senior judges could be given temporary authority to act in his place. Those who were Irish Privy Councillors could sign orders in Council or issue proclamations. As Kennedy would remark, a judge might drop into the castle of a morning on his way to court and as part of the executive make an order in council, and then go on to the bench and try an issue between the executive and the people. The influential barrister George Gavan Duffy, the last of the Irish negotiators to sign the treaty, who later fell out with the provisional government over the Dáil courts, and who much later became president of the High Court, regarded the Crown judges as corrupt and crooked with regard to habeas corpus. In fact, to their credit, in 1920, the senior Crown Judiciary had privately successfully resisted the establishment of a 3-judge tribunal to try cases without a jury. However, controversial judgments on habeas corpus, and particularly the notorious King's Bench division judgment in Allen's case, which led to convictions carrying a death sentence or penal servitude, seriously damaged their position. Later, Charles O'Connor, the Master of the Rolls in Egan and Macready, had refused to follow Allen. The difference suggested to many Republicans that the Allen decision was influenced by the personal outlook of the judges. There was also deep resentment at the way compensation claims had been determined. This was because compensation was recouped from the rates paid by the local population. Animosity towards the Crown judges became very pronounced. In late August 1921, during the truce and pending the tentative peace negotiations that were to be held in London, the Dáil had met in secret session to make contingent arrangements for the resumption of war if the peace talks failed. The then Minister for Home Affairs, Austin Stack, wanted extreme powers, including execution, to deal with the Crown judges. He argued that Crown judges were dealing with arms offences cases and compensation, and they had allowed compensation to British military who had destroyed property of Irish citizens without compensation, but had granted huge sums for compensation to policemen and soldiers. Stack wanted a decree passed that would allow the Minister for Home Affairs to make regulations against such persons, imposing penalties by fine, imprisonment, banishment from a particular area, or otherwise. Otherwise was to include the death penalty, and the trial of offenders could be by military or civil courts. Stack's motion was seconded by Patrick Rutledge, then a solicitor and a future Minister for Justice. Gavan Duffy objected, arguing that if the death penalty was to be included, that should be made explicit. He also argued that barristers should be on the list. He was concerned also that the Dáil, or the Grand Committee, which was an emergency representative body designed to function in the event that the Dáil could not meet, would not have control over the proposed regulations, and he wanted enforcement of the death penalty to require sanction from a civil authority. Stack was agreeable to the death penalty being specifically provided for, arguing that if the judges continued to be responsible for the execution of men like Allen without legislation of this kind, he did not believe that it would be possible to deal with them. He agreed that the regulations setting up the new courts would have to be laid down by the Cabinet, and also that approval of the death penalty would require the approval and ratification of the Cabinet. Rutledge wanted solicitors included on the list, as they urged their clients to go to the enemy courts. He also wanted the death penalty because, as they had no jails and they had nowhere to put prisoners, and he argued that the more drastic the action, the more effective it would be. De Valera, Collins and Griffiths did not dismiss the proposals. All displayed some unease about such a serious proposal, but equally they considered that if the truce broke down, then very serious steps would have to be taken. De Valera said that if the war went on, they would root out every enemy department. They would proscribe the courts and forbid their functioning, and the courts would have to function at their peril. Collins argued that the English government in Ireland was a usurpation and any official acting for the English government who was not exempted was guilty of treason. If war resumed, they should make clear what constituted treason, carrying a death penalty, and those English officials could then have no grievance. Griffith agreed, but he added that a civil enemy should be treated as a civil enemy and not a military one. He said he would require that there would be an appeal to a civil tribunal. The overall thrust was that the issue should be addressed at a later stage, if and when necessary, and in a more considered way. De Valera did, however, also indicate that a proposal such as that made by Stack should be on foot of a ministry or cabinet motion. He also said that the ministry already had the power, through the ministry powers under the Provisional Orders Decree, which was passed the previous day. That decree gave the ministry power to legislate without meetings of the Dáil if meetings were impossible because of a renewal of British action. De Valera said that the action could be ratified later by the House or the Grand Committee. He said that Stack should be content with the powers they already had under the Provisional Orders Decree, and he asked Stack to withdraw the proposal, which was duly done. Whether the Crown judges ever found out about this parliamentary consideration of their possible execution is unclear, but senior judges were already accustomed to the risk of attack or assassination by militant Republicans, and their lives were not untouched by the pervasive violence. The Recorder of Dublin received a licence in 1921, allowing him to carry an automatic pistol. Travelling out for the assizes, even under heavy guard, with military convoys with them, was extremely hazardous. Courts were guarded by military soldiers and often sandbagged. Crown courts were frequently unable to function because of intimidation and lack of jurors. Cases often did not proceed as they were adjourned and litigated instead in the Dáil courts. The county court judges, who had to preside in the bigger towns, were also at significant risk. Their decisions on compensation particularly aggravated Republicans. County Court Judge Dáil was forced to abandon his quarter sessions list in June 1922 in Claremorris. Just after taking his seat, armed local IRA men entered and threatened force to stop him proceeding because they said he was not functioning under the Republic. He adjourned the sessions. Justices of the peace were also frequently threatened. In July 1921, one justice of the peace in Cork was kidnapped and held captive for 10 weeks. Many courts of petty sessions ceased to operate. The position of resident magistrates had long been very hazardous. Often working in rural areas with little protection because of attacks on the RIC, they were physically very exposed to intimidation and attacks, and some of them were killed. Many resigned, and by 1922, their numbers were well reduced. By October 1921, the senior judges were also worrying about their tenure and lobbied the British government to good effect. Article 10 of the treaty provided that judges who retired or were discharged would be compensated for loss of office. However, the Crown judges got little information about the detail. By March 1922, Lord Chancellor Ross feared that the draft constitution could reflect the provisional government's own interpretation of the terms of the treaty, which he said might be completely distorted. Ross informed Churchill, the colonial secretary, of his fear that the electorate might pressurise the Irish government to remove a judge in certain cases where the judge's decisions, though right in law, may have given offence to some of the people in recent or past times. Ross was concerned that the judges who had given recent unpopular decisions in habeas corpus cases could be dismissed and their pensions threatened. The Crown judges later ascribed the ill feeling as stemming from a lack of understanding of their judicial role on the part of the Irish people. In May, when the British reviewed the draft constitution, they noted that it made no reference to compensation for the judges, and so the draft was altered to confirm that Crown courts would continue and a judge could stay on the same terms. Judges not appointed to the new courts were also to have their compensation protected. The occupation and later attack on the forecourts, signalling the start of the Civil War, were enormously stressful for judges and practitioners alike. After the forecourts were occupied, the judges had removed themselves to the King's Inns to operate the courts under guard, and later they moved to Dublin Castle. By May, Lord Chief Justice Maloney told a senior British official that the judges were simply waiting to see, will the tide turn or engulf us? Maloney acknowledged the praise for their efforts at continuing the operation of the courts in the King's Inns, but he believed that, ironically, this had only infuriated extremists who thought that by destroying the forecourts, they had destroyed us. He believed that the provisional government wanted him to go, and he had in any event resolved to depart if his judicial independence were compromised. In July, the senior judges signalled to the British that they did not want to be obliged to accept offers of judicial office under the new regime. Ross realised his own days were numbered, and in August he sent a memorandum to the Home Secretary outlining his skills that might be used elsewhere. Sure enough, in December, Ross's office as Irish Lord Chancellor was abolished. By October, the British had been focusing on the cold reality of the cost implications of compensation. There was a proposal which had the effect that judges who did not accept a position in the Free State or Great Britain, except for good reason, would suffer financially in their compensation or pension. The Crown judges successfully fought off this latter arrangement, arguing that some of them had a conscientious objection to serving as judges of the Free State. They argued that there would be different duties required of them to address the change in the national spirit, which was directed towards de-Anglicisation of its jurisprudence and judicial custom. They claimed that removal for misconduct by address to Westminster was different to a vote of both houses of the Oireachtas, whose future composition, aims and objects might be so different. Ultimately, new arrangements made in December provided for compensation, but the judges were nonetheless required to go through a detailed procedure for assessment of that compensation. Aside from tenure, there were also tensions between Maloney and Kennedy. In July, the failure of Maloney to alter the symbolic reference to Southern Ireland on writs that were issued angered Kennedy. Southern Ireland, I should say, emanates from the Government of Ireland Act and would have been absolutely abhorrent to radical nationalists. Kennedy demanded that the proper title of Irish Free State would be used. There was also discord in November over the transmission by Maloney of land registry documents to Belfast, which Kennedy saw as an important strategic issue in the context of Ulster's uncertain position. Ultimately, when the new courts were established in June 1924, few of the Crown judges were reappointed. Some of them by then were too old in any event. Some went to live in London. For most of them, it was a miserable end to their careers. Although they thought they had perfect security, words used by the Irish Lord Chancellor John Ross at one stage, their prestigious roles had collapsed all around them. The political reality was that by 1922, many of them were politically compromised in the eyes of the new radical nationalist leaders because they were not regarded as having been impartial. The gulf also reflects a deeper clash of judicial cultures. The climate had seismically shifted, requiring much greater structural judicial independence for the Ireland of the future. Overall, the senior Crown judges were protected because the British took a very close interest in them. By way of an unusual aside from a rather different war, the Crown judges' position may be contrasted with that of some Third Reich judges after the collapse of the Nazi regime. Unlike the Crown judges, they had no government to protect them. Many were taken prisoner by the Russians and died in camps. Operating parallel to the Crown judges, there were the judges of the Dáil courts. Arthur Griffith had long advocated the establishment of an alternative court system which would supplant British courts and help undermine their regime. In June 1919, arbitration courts were established by Dáil decree. They operated by consent of the parties and were to help prevent a legal vacuum arising from the difficulties facing the Crown courts and a potential descent into general lawlessness. There were also Dáil land courts which dealt with land disputes. The much wider-ranging four-tier system of Dáil courts was established in June 1920. Unlike the arbitration courts, they did not depend on consent and were thus a direct challenge to British rule. They garnered widespread support, partly because access to the Crown courts was restricted by Republican intimidation. Many unionists resorted to them to deal with issues such as cattle driving. Patriotism, however, was also a factor in their success. But ultimately, the Dáil courts were, as Kevin O'Higgins later described them, they had been forged as a weapon against the British. The Dáil courts were relatively unsophisticated and somewhat limited in jurisdiction. Many of their judges at the lower level were lay people, with lawyers acting as judges in the upper ranks. While the Incorporated Law Society did not impose any ban on solicitors appearing in the Dáil courts, the Bar Council had resolved on June 23, 1920, that it was professional misconduct for barristers to appear in the Dáil courts. Within the bar, there was also relatively little support for the Republicans. Austin Stack had found it hard to recruit suitable barristers to appoint as Dáil court judges. They did, however, secure the support of several, mostly junior barristers, some of whom would go on later to achieve legal prominence as judges in the new state, such as Cecil Lavery, Cahir Davitt, Conor Maguire, one King's Counsel, James Creed Meredith. Participation at a Dáil court was a very dangerous activity for all involved, and there were several deaths associated with them. Court sittings were initially held openly, but following British suppression, they went underground. Courts were held often at night in barns, halls, colleges, and the like. All the participants were liable to arrest, and the British military often raided them. Equally, Kevin O'Shiel, a Dáil Land Court judge, described sitting as a judge with 12 Republican military minders lined up on either side of his court. One judge, Diarmuid Crowley, was arrested by the British and imprisoned with hard labour for about a year. Most judges travelled to their courts covertly to avoid arrest. Conor Maguire, a land judge, described going to a rural court dressed up in sports gear with his golf clubs. Charles Bewley, a barrister who practiced widely in the Dáil courts, later admitted that instead of feeling like prosaic barristers earning fees, they felt like they were playing some romantic role in a patriotic drama. After the truce, imprisoned justices and court officials were released by the British. Maguire later commented that at that stage, the Dáil judges were lionised. However, their situation was to change dramatically later. Initially following the treaty, Republicans expected that the Dáil courts would become the established courts, and they remained very busy and they operated widely, even taking over some official courthouses. However, within a few months, they were to be terminated and the Crown courts were revived. Dáil Court Judge Diarmuid Crowley, who, as Mr. Justice Hogan has already described, had been released by the British, was at the centre of the confrontation with the Provisional Government over the suspension of the Dáil courts and its adjudication of cases which challenged the legitimacy of the treaty and the Provisional Government. He was imprisoned by the Provisional Government in Wellington Barracks for 10 days. The Provisional Government had intended to establish a committee to advise on the structure of the new courts, but this was delayed by the Civil War. However, they formally disbanded the resident magistrates, many of whom had no legal qualifications, and replaced them with sympathetic, legally qualified district justices. When the Dáil courts were suddenly terminated, their former judges found themselves facing great uncertainty. Arising from the issues concerning the alleged illegality in their constitution, there was the worrying problem that they might face claims, and consideration had to be given to a possible indemnity for them against claims. Fortunately, some of them became district justices. Becoming a district justice, however, did not necessarily provide security. Solicitor George Cussen's first year in office reportedly saw 18 courthouses burnt down in his area alone. More senior Dáil judges who supported the treaty were selected by the provisional government for sensitive roles. Creed Meredith was picked by Kennedy to advise on a system for winding up the Dáil court's cases. He was later appointed to the High Court in 1924 and ultimately the Supreme Court. In August, former Dáil Court Judge Cahir Davitt was handpicked by Kennedy for the role of Judge Advocate General, a job Davitt undertook very reluctantly out of a sense of duty, realising its acute sensitivity in a time of civil war. He was still only 28 and had relatively little experience. He became responsible for the legal aspects of court-martials and discipline, of which he then knew precious little by his own admission. Davitt later recounted how he quickly made his way to Eason's, where, as you could do then, he purchased the British Army Manual of Military Law. Within a short time, he was also given the daunting task of helping to establish the new military courts and relying on the text of the manual for the procedures he was to adopt. The enormous responsibility attaching to Davitt and his young legal team is evident from the fact that during the Civil War, there were 77 executions, at least, depends on how they were categorised. Davitt was holed up for months in a military barracks, subject to attack. He was assisted by several other young barristers, among them Charlie Casey, a future Attorney General and High Court judge. Davitt and many of his colleagues were included in the Republicans' list in late November of those who were to be executed for involvement with the military courts. Another separate source of ongoing anxiety for some lawyers in 1922 was the continuing uncertain position of the already partitioned North. The possible extension of the Civil War to Ulster could have killed the treaty and reopened arrangements on its status. Similarly, even if the treaty survived and if Ulster opted out, it was unclear whether the work of the Boundary Commission would result in a much reduced and possibly unviable Ulster. New Northern Irish courts had been established in 1921. While efforts were made to maintain the links and facilitate cohesion between Dublin and Belfast, and particularly within the bar, partition forced practitioners, new and old, to choose where they would live and where they would practice. And ultimately, in 1925, circumstances arose resulting in the bar becoming split as between North and South. There were many barristers whose work was only moderately impacted by the unrest going on around them. To a large extent, the more serious impacts arose for individual barristers whose political stances were such that they were put in the way of trouble. And it depended also whether they were intentionally involved or whether they became otherwise embroiled in political affairs through circumstances. For all barristers in Dublin, there was the immediate chaos resulting from the attack and siege in the forecourts, which was their place of work. There was work available if cases could be heard, such as cases arising out of political and military events, compensation claims, restructuring of the legal and administrative system, and land transfers. It was also becoming clear that if the treaty were ratified and implemented, the constitutional transformation it created would open up some entirely new work for some barristers, especially those who had become politically active. However, the ongoing delay in 1922 in arrangements to establish the new courts created uncertainty and exacerbated difficulties. A marked change was emerging in the political and social character of the bar. Government had always been an important source of legal preferment, and the change of government drastically altered who might benefit. A new simplified system was on the cards, and the old reliable pathways to the bench and legal prominence were gone. For some, the changing atmosphere proved unwelcome. First Sergeant Sullivan, the holder of a historic honorary legal title at the bar, who was a constitutional nationalist, was resolutely opposed to Sinn Féin. He had acted as a Crown prosecutor between 1919 and 1921 and was a temporary High Court judge for the Southern Circuit. A prime Republican target, 2 attempts were made on his life in 1920. In April 1921, his house in Rosscarbery in County Cork was burned by the IRA. By 1922, he had had enough, and along with his 12 children, he moved to London to practice there. In contrast, his cousin Tim Healy, the prominent King's Counsel and Irish parliamentarian in Westminster, who had also been a prominent constitutional nationalist, chose to remain. He had increasingly allied himself with Sinn Féin, and by the end of 1922, he was appointed the first Governor-General. That appointment was a counterpoint to the election of former Unionist Irish Lord Chancellor Lord Glenavy as chairman of the Senate in December 1922. Prominent Unionist Silk Gerald Fitzgibbon, a Trinity MP, transitioned to representing Trinity in the third Dáil and was later appointed to the Supreme Court in 1924. Above all, however, it was the emergence of a group of younger, influential Catholic, radical nationalist lawyers that was really the most striking change. They were tested at a relatively young age in very challenging roles that few of them could ever have imagined, and it propelled them to prominence. Those who supported the treaty benefited far sooner than those who did not, and they were picked for pivotal roles, important briefs, or the bench. John O'Byrne and James Murnaghan, 2 relatively experienced juniors who had acted as background advisors at the London negotiations and were later members of the Constitution Committee that worked on the draft constitution, both of those went to the bench ultimately. O'Byrne was the junior in the Childers case the following November 1922. Murnaghan was appointed to the Supreme Court in 1925, and O'Byrne had succeeded Kennedy as Attorney General in 1924, and likewise later, as I said, he ended up in the Supreme Court. Notably, those who had been picked out and who had worked closely with Kennedy, who had enormous influence on the deployment of counsel for important work, they tended to advance quickly. Thus, Tim Sullivan, Kennedy's second senior in the Childers case, was selected as President of the High Court in 1924 and became Chief Justice in 1936. Kennedy himself, of course, became the first Chief Justice in 1924. A young John A. Costello, who was Kennedy's junior in Egan and Macready and his assistant later when Kennedy was Attorney General, was himself to become Attorney General in 1926, and later, of course, Taoiseach. Propelled initially in a more political direction was Patrick McGilligan, who was called to the bar in 1921 and who had been helping with transitional arrangements. By 1923, he was elected to the Dáil and was Minister for Industry and Commerce by 1924. He later became Minister for Finance, Minister for External Affairs, and later again, Attorney General. Those who opposed the treaty often had to wait for appointments until De Valera got to power in 1932. Conor Maguire became Attorney General in 1932 and later Chief Justice. Gavin Duffy was appointed to the High Court in 1936. Michael Comyn, who had acted for Childers and advised De Valera, became a founding member of Fianna Fáil, and he was elected a senator in 1928 and appointed a Circuit Court judge in 1936. Like the bar, many solicitors experienced relatively moderate disruption, whereas others closer to the political world were sometimes much more seriously affected. The change of government created a shake-up in the handling of state work. The existing Crown solicitors' positions were terminated, and new sympathetic state solicitors were appointed, who would take over the politically sensitive issue of the management of prosecutions. On the treatyite side, Michael Corrigan, who had worked with Kennedy, became Chief State Solicitor. His role, however, led to his Rathmines home being bombed out in January 1923 and his family's solicitor's office being set on fire. Treatyite solicitor Patrick Hogan became Minister for Agriculture in February 1922. Anti-treatyite solicitor Paddy Rutledge's situation, however, was different. He became Minister for Home Affairs in De Valera's rival Republican government in October 1922 and fought in the Civil War and was shot and seriously wounded. Elected a TD in 1921, he had continued as a TD in 1952, and between 1932 and 1941, he became a government minister. Similarly, anti-treatyite solicitor Patrick Little, who worked with Childers and was associated with the Four Courts garrison, later became a Fianna Fáil minister. Some solicitors experienced the very rough end of Republican violence. Solicitor Michael Healy, a former MP and brother of Tim Healy, who was very anti-Sinn Féin, was put at gunpoint onto a steamer leaving Cork in reprisal for having advised Cork merchants that payment of Republican levies would not discharge their liability to income tax. He stayed away for 2 months, and later an attempt was made to burn down his house. In January, 2 Crown solicitors were kidnapped and later released. And then there is the scarcely credible experience of the Crown solicitor for Cork, the irrepressible Jasper Wolfe. Based in Skibbereen, Wolfe was a Protestant Home Ruler. His clients included Anglo-Irish loyalists, landlords, local authorities, and boards. He acted for claimants seeking compensation for malicious injuries and damage to property, and was very skillful at using garnishee orders. Between 1921, he endured an array of troubles: an attempted road ambush, being chased by gunmen on the quayside in Baltimore and hiding in the fishermen's nets, taken prisoner twice, sentenced to death 3 times, once in his absence, a narrow escape from assassination on the same day that a solicitor in Dunmanway was shot at his hall door. Another narrow escape from having his house torched, and later his house was commandeered by both the irregulars and the Free State troops. His practice, naturally, suffered significantly, and he ceased to be Crown Solicitor at the end of 1922, when the role was terminated. However, he was a quintessential survivor. Wolfe's practice bounced right back. He even advertised in 1923 that he was prepared to act for all and sundry, a signal sent to Republicans in the area that he was willing to act for them, and sure enough, they were soon knocking at his door. He was later elected an independent TD and became president of the Incorporated Law Society in 1940. All in all, it is safe to say, 1922 was a calamitous year in the legal world. Revolution and civil war create divided loyalties, and for certain groups, those loyalties are not simply a matter of personal inclination. Loyalties are sometimes particularly difficult to square with other obligations, such as the obligations of the police and the military. Similarly, the Crown judges had obligations to honour the judicial oaths they had taken. The barristers and solicitors who were officers of the court and were also obliged to act in the best interests of their clients. Some solicitors had Crown appointments. Barristers had to act in accordance with the cab rank rule. Collisions of obligations were inevitable. For the most part, the Crown judges and other legal office holders were indelibly associated with the British regime, and unlike legal practitioners, they had little possibility of repositioning themselves to avoid danger, even if they had wished, and many, of course, would not have wished to do so at all. The British senior judges were protected. Nonetheless, they were actually lucky to have escaped with their lives. Others scattered elsewhere in the country fared less well. The Irish experience of the courts between 1920 and 1922 demonstrates how difficult is the role of the courts in wartime. Those inherent problems were exacerbated further in Ireland by the deliberate usage of Dáil courts as a weapon of resistance from a very early stage. The Sinn Féin policy of using Dáil courts to supplant the Crown courts increased the strategic significance of both courts. It magnified the scrutiny of the role of the judiciary and of the professions in a time of war. Not surprisingly, it led in time to British suppression of the Dáil courts and imprisonment of Dáil judges and officials. That process added those steps to the familiar menu of wartime tactics. So the idea that the Dáil would have debated the suggestion of severe penalties, including execution, against Crown judges, solicitors and barristers in that environment in 1921 is less shocking than might first appear. It was the next phase of an escalating war that saw the legal system and its personnel become targets of war in themselves. One might ponder if that awful scenario debated in the Dáil had come to pass. Might one have seen a Crown judge facing execution applying to a Dáil Supreme Court judge for an order of habeas corpus? In the environment of war, the concept of the rule of law, other than, say, from international conventions, can be difficult to apply. To take the situation in Ireland, that would have begged the question, whose law? That of the imperialist British regime, or that of the revolutionary movement who saw the British as illegal usurpers? Or later, that of the treaty-eyed government enforcing the treaty, or the dissident republicans' concept of republican legitimacy? Fortunately, things never reached such a low point, and that dark precedent, debated in 1921 in the Dáil, was never established. 1922 was bad, but in fact, it could have been a great deal worse. Thank you very much.
On behalf of the Chief Justice and on behalf of all of the members of the Decade of Centenaries Commemoration Committee, and on all our behalf, I would like to thank Bláthna very much indeed for an entirely engrossing and thought-provoking lecture. There are just things I want to mention about the programme. This Saturday is the last day on which there will be Four Courts 100 guided tours taking place. There's also an app which is available from the App Store, which enables you to take a self-guided tour of the Four Courts. And there's also a photographic exhibition in the Round Hall, which will remain in place until the end of August. And you can, I think, visit the exhibits in that exhibition and with the advantage of a glass of wine in your hand. So thank you all very much for your attention.